Why a medical professional should never buy a disability insurance policy through their medical association. Every medical professional should have their own occupation disability insurance policy to provide them with financial peace of mind and security if they were to become disabled. But in my experience, I don't think a medical professional should buy a disability policy through their employer. Why would I suggest a higher cost policy, an individual disability policy, when I, as a lawyer, am not making a dime on commissions from the sale of the policy? Learn more about why I'm so strongly in favor of individual disability policies. While some disability insurance is better than none, what you don't know about how you buy your disability policy can come back and bite you in the future. I'm often asked, should I buy my policy through an independent agent? Should I buy my disability policy through my employer? Well, I've already given you a big hint. I think you first need to know the difference between an individual disability insurance policy and a policy that you purchase through your employer, be it a hospital or a medical group. In terms of an individual disability policy, you're purchasing an own occupation policy that's tailored to you. You've entered into a contract with a disability insurance company like the Standard, Guardian Berkshire, Principal, Emeritus Union Central, or Mass Mutual. If you become disabled and your benefits are denied, you're entitled to file a lawsuit in state court alleging a state law breach of contract claim. You can claim compensatory and punitive damages, bad faith damages, interest, and attorney's fees. You're allowed to take the deposition of the insurance company adjuster and the insurance company physician who said you weren't disabled. You have the right to a jury trial. And that's where you want to be if your individual disability benefits are denied. But that's not the case in an ERISA disability policy. On the other hand, in an ERISA disability policy that you purchased through your employer, your case is going to be governed by a federal law called ERISA. The ERISA statute governs not only disability insurance policies, but group health insurance policies. You know how group health carriers are. They try to limit health insurance coverage. They deny coverage, they cut your bill, and they make you wait forever to get paid. ERISA disability insurance carriers are no different. Every ERISA disability policy has what I call a get-out-of-jail-free card. It's a discretionary clause in the policy that lets the ERISA disability carrier interpret the terms of the policy and make the decision whether or not you're disabled pursuant to the terms of the policy. This clause lets the fox run the henhouse. There are many traps for policyholders in an ERISA disability policy. For example, there can be a highly restrictive definition of your occupation, an unfavorable standard of disability, limits on how long subjective medical conditions or mental nervous conditions are paid, and a reduction for other income benefits like Social Security disability benefits or other disability insurance benefits. The ERISA statute has strict rules on the disability claims process. That sounds great, but the rules generally favor the disability carrier. If your claim is denied, you have to file an appeal within 180 days of the denial. The appeal is the trial of your case. No new evidence is allowed if a lawsuit has to be filed, and rarely is there testimony. In fact, you aren't going to testify, and your doctors aren't going to testify. And if there's anything new, you can't submit it. The federal judge's hands are limited by this discretionary clause. It's like a golden handcuff. It's practically impossible to get a federal judge to reverse a wrongfully denied disability claim. So at the end of the day, that ERISA disability policy may not be worth what you paid for, even with a discounted premium. I recommend that every medical professional have an individual disability policy. Don't be suckered into having an ERISA-sponsored individual policy like some agents suggest as a supplement. These types of policies are rarely held by courts to be individual disability policies. I'm not wild about group policies, but if you have both, you need to understand the interaction and the limits of these policies so you really do have financial peace of mind if you become disabled. Do yourself a big favor. You owe it to yourself and your family to know the terms not only of your individual disability policy and a group disability policy if you have both. And you need to know why a group policy is not going to provide you with financial security. Don't make a mistake that can rob you of your peace of mind and financial security. And don't assume that your employer, be it the hospital or your medical group, has the understanding to understand why you should have an individual disability policy, why the group policy they're offering to you really isn't worth the money that's being spent, or that the agent understands. Because after all, the agent is after their commission. Don't delay. Make the call 727-894-3188 and have a comparison of your policies so that you understand what it is you have in terms of your disability insurance coverage.